Okay, hi there. Dr. Matthew J. Trom here. Again, welcome back from your break. This is the second video in my series on copyright for engineers. Just a quick reminder in case you didn't start with the first video. Um, that I'm not a lawyer. This lecture is not meant to be legal advice. It's just for educational purposes. So please consult a lawyer before making any binding legal decisions. And I am borrowing some legal definitions and some content from Professor Danny Sokol, who is a law professor in the Levin College of Law at the University of Florida. And I'm borrowing this content with his permission. Okay, so let's jump back in where we ended last time, where we were talking about just a summary of what copyright does and does not protect. And let me just say that because I forgot to say this last time, but let me say it now that up until now, you guys have probably felt constrained by copyright, right? It's like, oh gosh, I have to pay for a new textbook every time I take a class, or I really want to listen to this piece of music, but I have to buy it, and my God, that's annoying. Um, and so up until now in your lives as sort of minors and students and stuff, copyright probably seems very draconian and very restrictive. But as you are transitioning from your lives as minors, children, students, into your lives as practicing engineering professionals, all of a sudden copyright is going to have kind of a new spin to it, a new feeling, in that whereas it was previously a hindrance to your ability to access content, all of a sudden it's going to become a great help in helping to defend your creative works and your intellectual property from being, poached by others, in a way that doesn't give you either financial gain or recognition for that creative work. So again, it's just kind of something that I wanted to mention that's important about copyright is as you become engineering professionals, you'll learn to love copyright because it will ultimately protect a lot of your creative works from getting poached. The same way that things like textbooks and songs and videos and stuff that you wanted to watch that were covered by copyright, in your youth and your childhood, seemed restricted. So anyway, it does ultimately protect the rights of the creator, which you guys are becoming because you're now practicing engineers. Well, at least almost. So what we were talking about before was that copyright law number 3 here also regulates um, ownership issues and creative works made for hire. And I sort of hinted at this question of who owns this particular lecture. Now, I've told you guys in 4501 that the reason that I post my videos to YouTube and not just directly to Canvas is because after you graduate, you no longer have access to the Canvas site, but I want to be able to make sure that you can still watch the videos and access the course content. And so I post everything on YouTube, which is a publicly accessible, um, you know, DIY video archive, and that's true. All that is true, but there's actually another reason, which I've kept hidden until now. Since we're talking about copyright, I will reveal it, and it's that at least according to current copyright law in 2021, as I'm recording this, a faculty member at a university owns their content until that content is posted on a university owned learning management system. And at that point, the copyright control passes and ownership passes to the university. And so, another reason that I post all my stuff on YouTube and just give you guys links from Canvas over to YouTube so that you can watch it is so that I maintain ownership and copyright of all the video content of this course. So if I needed to or wanted to for some reason, let's say I wanted to package the course into something that people outside of the University of Florida paid to access, or at some point in the future, if I left UF and went to another university, I could take all of this content with me and retain the copyright to it. If I ended up posting it instead on Canvas, then UF would own all of it, and I would not be able to take it with me, right? So there is sort of that underlying method to my madness for keeping everything posted on YouTube and giving you guys access to it that way. So it serves two purposes, but a really interesting question that's emerged as a result of the corona virus um, COVID-19 pandemic is all of us faculty are now teaching online, right, for the most part, and we are teaching through a an online media, probably Zoom or something like that, that the university pays for. And so if we record those lectures, even if we end up posting them to YouTube, does the university in fact own them and own the copyright to them because they were recorded using a university owned and paid for Zoom account? So I don't know that there's been a legal case yet that kind of asks that question and resolves that issue, but that will probably be something that will come up in the near future with respect to the legality of who owns the online content that has been generated during this time period. So anyway, it's a pretty interesting academic topic that probably will see the light of day in the not too distant future. But anyway, so let's move on. So the point behind this slide is just to kind of point out that copyright is unique from the other three types of intellectual property protection in that it protects the works of authorship, but not the underpinning ideas, right? Whereas the other three, patents, trademarks, and trade secrets, really are meant to protect the underpinning ideas and not necessarily the way in which those ideas are transmitted, right? So patents protect inventions or discoveries. Trademark protects word, phrases, symbols, or designs that identify a source of goods and services so that one brand, one company can distinguish its products from another company. Trade secrets protect information that is held confidential to provide a competitive advantage, but copyright protects original works of authorship, not the underpinning ideas or discoveries that are communicated in those works of authorship. And so, again, this goes back to that idea of you guys being digital natives and being able to sort of think differently and bigger about these four types of intellectual property, because for you the world has always been computerized and the internet has always existed. There are, I think, a lot of interesting opportunities here, particularly for you guys as creative professionals moving into your engineering careers, to mix and match these three types of intellectual property protection that do in their own separate ways protect ideas and discoveries with copyright that protects original works of authorship, right? And so, one example of that is, for example, an instruction manual, right, in a product that your company might produce. That instruction manual itself, even though it does convey ideas and potentially even discoveries that your company is trying to commercialize, the instruction manual itself, those ideas and discoveries are not protected in the manual as it's been written, but the manual itself is protected or could be protected by copyright because it's a written or an online medium, and so you can imagine a combination of like a trade secret and a copyright or a patent and a copyright that gives you like multiple different layers of protection and coverage for your intellectual property, because you're protecting simultaneously both the ideas through, for example, a patent, and the means in which those ideas are communicated through copyright, right? So you can, I think, combine these things together to make your intellectual property protections even more powerful than any of the individual IP protection techniques by themselves. And I think, again, given that the world is almost fully transitioned now to digital communication, you guys as digital natives will be able to come up with all kinds of cool and creative ways to do that are sort of beyond the thinking of us old guys. So here's something that's super interesting, right? And this is kind of the beginning of the story about why I think, at least in my opinion, that copyright law, at least in the US, is incredibly messed up. And it's this idea that in the US, content is born copyrighted. And okay, born copyrighted is a term that I made up. And so what in the heck does that mean? Well, according to the US Copyright Office, copyright exists the moment the work is created, and formal registration is not required to establish copyright protection. Now, this was not always true. It used to be that if you had a work that you wanted copyrighted, you would actually have to disclose it and report it to the U.S. federal government to get that copyright protection. But now modern copyright law in the US says no, it's just the moment that you create something, it's copyrighted, and nobody, you don't have to claim the copyright to it or anything like that. It's copyrighted the moment that it comes into existence. And so, like, think about how powerful this is for the creators, right? You don't have to do anything to protect the means through which you communicate your ideas. The moment you have a pencil and you set it to paper, the moment that you start clicking keys on a keyboard, the moment that you start recording your voice for any sort of creative work, everything that you produce is protected by copyright and cannot be legally copied by anybody else, a competing company or anybody else who's trying to uh, generate a profit, make a living off of your creative productions. So this is really good for creators, not so good for the commons, for consumers, but very good for creators because it's this incredibly powerful rule that basically says that anything that you create is protected the moment that you create it, right? So that's very good for you guys as creative professionals. The caveat to this in the law is the second sentence here, the second statement here, to bring a lawsuit for copyright infringement of a U.S. work, the work must be registered with the U.S. Copyright Office. And so even though everything that you produce is born copyrighted, right, it's immediately protected under copyright law the moment that it's created, in order to actually sue somebody and win in a court of law, you do have to register that creative work in advance. And so here is the Federal Copyright Office website. And you can see right here, there's a button that says register, and if you click on that button, it'll take you to the copyright registration section of the website, and there is where you legally insert your information about the material that you've created that you want to cover under copyright law, so that if somebody copies it or steals it, you can sue them. So it does cost a little bit to do this. It's not very much, especially with respect to like patents and trademark registration. But it does cost a little bit. It's not zero to copyright, but it's relatively inexpensive compared to the other pay to play intellectual property protections. And so my suggestion is, if you guys do generate a creative work that you think has monetary value, pretty good idea to go onto this website and to just pay the small fee and to get it copyrighted. Well, let me say that better. It's already copyrighted the moment you created it, but get it officially registered as a copyrighted creative work, so that you can then defend it in a court of law if somebody comes along and tries to use your creative and now copyrighted and registered material for their own monetary gain. So that's the site that does that. Okay, so there are a couple of reasons I think that you want to register creative works as copyrighted material. First is that it provides a public record of the fact that a copyright exists and who owns it, right? So there's now a paper trail that this document that you produce is real and it belongs to you, right? So that's usually good in a court of law to be able to prove that. That's number two, legally traceable, certifiable identification and registration of the creative work. And then number three here is actually pretty interesting and important, which is that registered works may be eligible for statutory damages and attorney's fees in successful litigation. So contrast this against patents, right? Where if you've seen my patent presentation or even my trade secret presentation, that patents are really expensive, not just to get a patent, but also to defend a patent. And a lot of cases, who infringes on a patent or not, according to the legal system, is really just a matter of who has more money to throw at the court case that's deciding patent infringement. And ultimately, companies can infringe on patents and put smaller, less well financed competitors basically out of business by just burying them in legal fees. Here with copyright, if you end up bringing a copyright suit and you're successful, you can recoup your legal fees, right? You can actually make the person who violated copyright law or violated your copyright pay all your legal fees, right? So this has the potential. Again, remember I was talking about kind of mixing and matching up here, mixing and matching different types of intellectual property protection to kind of bolster each other and increase your protection. That has the potential to be one of those really cool combinations where, okay, you've got a patent and a copyright. The patent covers the idea, and then the copyright covers the medium in which that idea is communicated. And you could potentially take somebody to court and sue them for a copyright violation and win and make them pay your legal fees, right? So it's this incredibly powerful aspect of copyright law that basically okay, yes, you have to pay legal fees perhaps as you're going through the process, but basically absolves you from that financial responsibility of defending your copyright, provided that you are in the right. Okay, so I see here that I'm right at about 16 minutes. So I said I'd stop every 15 minutes to give you a break. So let me stop, and we'll pick this up in another presentation here in just a moment. So see you in a sec.